Good afternoon. Thank you very much for having me here at the CISO Africa Live event. My name is Isabella Hofmeyer-Pretorius, and I'm a legal advisor in risk management at Capital Bank South Africa. Today, I want to talk to you about a topic that I'm very passionate about, which is data privacy, and looking at the risks and impacts that it has on organizations. Now, data protection and the right to privacy are not new concepts, but in recent years, there's been a number of new laws and standards developed to regulate the responsible use of personal information and to balance the rights of the data subjects against those of the organizations processing their data. The age-old saying that knowledge is power is especially relevant now during the fourth industrial revolution, when big data is the oxygen keeping businesses alive and relevant. It is also important to take cognizance of the fact that privacy and innovation are not mutually exclusive. Compliance with data protection law simply requires transparency, responsible and ethical processing of personal information, and it forces organizations to think about the way they use personal information and to be creative in how they develop products with privacy in mind, and to put clients in a position to make decisions to sign up for products or services that align with their personal privacy preferences. Data privacy impacts all processing activities that relates to personal information. So if we look at the impact on an organization, we first need to look at what is personal information and then what is processing. So personal information is information in any format relating to an identified or identifiable living person, or in South Africa, that is also extended to existing juristic persons. And the data subject is identifiable if he can be identified directly or indirectly, in particular by reference to an identifier, which could be anything from an ID number, an account number, an employee number, a name and surname, even an IP address. It can also be accumulated information that together has a reasonable likelihood of resulting in the identification of the data subject by any person in possession of such information, even if the information is encrypted, masked, or pseudonymized. Those people who have the keys or the ability to unmask or decrypt the information would still be considered to be in possession of personal information and processing personal information. It is only if it is completely de-identified with no way of bringing it back to its original identifiable form that it can be said to be de-identified or anonymized data. If the data can be combined with another data set to re-identify a data subject, then it is still considered personal information. The question of processing is a very wide concept. Processing really means anything from collection, usage, storage, deletion, really anything that you can think of to do with personal information is considered to be processing. So understanding the impact on an organization, you have to consider the current business or processing practices. So you have to look at where the personal information is being used in the organization and for what purpose. Data privacy and data protection compliance will always be a moving target as long as business processes change, new products are brought out, new technologies are introduced, or even new acquisitions or mergers with other organizations. The use of personal information must align with consumer expectations. One of the biggest risks when it comes to the usage of personal information is not the fact that there is a law protecting an individual, but it is whether that individual is comfortable with the way that organizations use it. And simply saying that you are bringing out a more affordable product or service or something that is more convenient to a consumer would not necessarily mean that the consumer themselves are comfortable with what organizations have to do to be able to provide that to them. So when it comes to data privacy risk, I've divided it into four main categories. The first being regulatory compliance, then information security, legal risks, and reputational risk. So for regulatory compliance, there are many different data protection laws around the world, and you'll need to look at your organization and which data protection laws applies to it. So firstly, you have to look at the local law. In South Africa, we have the Protection of Personal Information Act that has recently become effective, and we have a compliance grace period to fully comply with the Act by June 2021. But we don't only look at the local laws. There are numerous other laws in different jurisdictions that also has extraterritorial application, or that applies to the residents or citizens of those countries. A few of these to keep in mind is the General Data Protection Regulations in Europe, which is currently seen as the gold standard for data protection. And it applies extraterritorially to organizations that are not based in the EU, but that offer goods or services to clients in the EU. It will also apply to organizations outside the EU to the extent that they do monitoring of behavior of individuals or data subjects in the EU. The California Consumer Protection Act applies to residents of California. So you would always need to look at whether your client base or data subjects' personal information that you process could relate to residents of California. The Nigerian Data Protection Regulations also speaks to and applies to Nigerian citizens. These are by no means an extensive list of the laws that could apply, and it is a discovery exercise that every organization will need to undertake and consider the processing practices and the data subjects whose personal information they are processing. On information security, I know this is an information security event, and everyone here probably knows a lot more than me about information security. But just to align with the legal requirements, you have to keep in mind that organizations have a duty of care to take appropriate, reasonable, technical, and organizational measures to protect personal information. The best way to demonstrate that an organization is doing that is by aligning with some industry or best practice standards. Most organizations also have a certain level of confidentiality or a duty of confidentiality owed to their clients or their employees or even their vendors. And the data privacy breach may be wider or narrower depending on the legislation applicable to your organization. In South Africa, a data breach is quite wide. It's considered any event where there's reasonable grounds to believe that personal information has been accessed or acquired by an unauthorized person. So that would include unauthorized persons internally, externally, whether it was negligence, whether it was malicious intent, it does not matter. It's only the question of whether there's reasonable grounds to believe that an unauthorized person acquired such information. The legal risk can also be a number of different risks and issues that can be brought against an organization. Uh, Civil claims for damages can be brought by any data subject that actually suffered a loss or harm. Uh, Breach of contracts with clients and vendors. All organizations must look at what their contractual obligations are, and especially where uh, agreements refers to compliance with relevant laws. You have to go look at which laws actually apply to the processing activity that your organization undertakes. Then there's also vendor damage claims and indemnities, where organizations make use of operators or processors or even sub-processors, and you have certain contractual clauses that puts obligations on you as a controller or responsible party or on those sub-processors. And where there is non-compliance with the contractual terms, even where sometimes it may not be a breach of a data protection law, there may also be claims for damages or indemnities that would apply. Then most likely the biggest risk these days is the reputational risk that organizations suffer, not only when there is a data breach, but also when there is unethical practices around uh, data processing. I think we've seen quite a lot of that play out in the media. There was a wonderful or disturbing documentary recently on Netflix called The Great Hack, which gave a lot of insight into the usage of data by Cambridge Analytica and Facebook, and how that information can be used to target people, to get people to change their minds. And in this case, it was used in influencing elections in the US and in the UK. There's also the fact that while you have regulators that may not either have the powers in law or may not have um, the resources to fully investigate or uh, take action against every single data breach or non-compliance that is reported to them, they the use of the media and the court of public opinion has often been used um, to get the message out there and to try and discipline organizations or get them to change their ways. Um, on that part, in my personal opinion, public awareness is extremely important. Um, what I've seen recently, also with a few large scandals on data breaches, is that the public is largely unaware of how data is being used for legitimate business purposes and sometimes illegitimate business purposes. And it is important to start educating our public so that they know when things are uh, inappropriate, where it could damage them, or where, if it is reasonable business practices and appropriate security safeguards are put in place, that it does not cause panic when it comes to that usage of data simply because the public is not aware of what is happening. So then I just want to highlight a few high-risk data processing activities. Like I mentioned before, data protection laws and data privacy really just forces organizations to start really thinking about what it is that they are doing, how they are using personal information, and to look at what are the different ways of achieving the same outcome by protecting the clients as well as developing products and services that are personalized, that are relevant, and that make life convenient for their consumers. So the areas that I've identified is the acquisition of personal information from a third party. In general, a lot of data protection laws require the collection of personal information directly from the data subjects, but they generally do allow for exceptions. But when you do that, think about those exceptions and make sure that it is communicated in a transparent and plain language way so the data subjects feel that they understand and that they are in control of what is happening with their information. The use of geolocation and tracking of movement is also a high-risk processing activity. If that type of information gets in the wrong hands, it can be extremely dangerous to individuals, especially where it is linked to the movement of minors. Then biometric information is a category of special personal information that is used more and more these days for security purposes, but that also requires the balancing of the rights and duties to say when is it appropriate to rely on biometrics and why is it justified. And wherever possible, where it is not an absolute necessity to rely on biometrics, to also provide consumers with a choice. And if there is another way that would not be such an infringement of the right to privacy that requires processing of special personal information. Blockchain technology is also an interesting one because data protection laws generally require the right to deletion, which is still quite an interesting development in blockchain to see how that would be possible to delete that personal information somewhere in the blockchain. Automated decision making and profiling. There's some legal requirements around that, but also the risk of biases in automated decision making and profiling that could be used to target individuals, or that a profile could negatively impact an individual or data subject with what they have access to. Machine learning is also a tricky one. You need data and you need accurate data in large volumes to get good results from machine learning. And you need to look at whether the data that you have can lawfully be used in training your machine learning. Selling of data. Also, some laws now specifically allowing for the opting out of selling data, while other laws prevents it completely, or some may require consent. So before simply sharing, trading, selling data to any third parties, that's definitely something that needs to be considered. And then a topic that we've seen a lot, and I'm sure everyone has experienced it as well, is unsolicited electronic communications and target marketing, where I'm sure we've all felt sometimes that our phones are listening in on us by the type of marketing materials that we are receiving online. Usually that is not the case that your phone is spying on you in that sense, but it is tracking what you are searching for, what you are interested in, what you are posting on different social media platforms, and a lot of that data can be used to target market to you. Unfortunately, the one that is probably the most annoying to most people is the cold calling which at this point does not seem to be included in too many data protection laws that would include the phone calls and marketing calls. Yeah, I'm sure there are a lot more high-risk data processing activities, and with technology, this changes almost on a daily basis. But these are just a few that I thought I would highlight to you today. So thank you very much for your time, and I'm happy to take any questions that you may have.